Constitution of India, Part 11, Relations between the Union and the States, Chapter 1, Legislative Relations, Article 245 to Article 255. Distribution of legislative powers. Article 245, Extent of laws made by the Parliament and by the legislatures of the states. Subject to the provisions of this Constitution, Parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. No law made by the Parliament shall be deemed to be invalid on the grounds that it would have extraterritorial operation. Article 246. Subject matter of laws made by the Parliament and by the legislatures of the states. Notwithstanding anything in Clause 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in List 1 in the 7th schedule in this Constitution referred to as the Union List. Notwithstanding anything in Clause 3, Parliament and the subject to Clause 1, the legislature of any state also have the power to make laws with respect to any of the matters enumerated in the List 3 in the 7th schedule in this Constitution referred to as concurrent list. Subject to the Clause 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in List 2 in the 7th schedule in this Constitution referred to as state list. Parliament has the power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Article 246A. Special provision with respect to goods and services tax. Notwithstanding anything contained in Article 246 and 254, Parliament and subject to the Clause 2, the legislature of every state has power to make laws with respect to goods and services tax imposed by the Union or by such state. Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or of services or both takes place in the course of interstate trade or commerce. Explanation. The provisions of this article shall in respect of goods and services tax referred to in Clause 5 of Article 279A take effect from the date recommended by the Goods and Services Tax Council. Article 247. Power of Parliament to provide for the establishment of certain additional courts. Notwithstanding anything in this chapter, Parliament may, by law, provide for the establishment of any additional courts for the better administration of laws made by the Parliament, or of any existing laws with respect to a matter enumerated in the Union List. Article 248. Residuary powers of legislation. Subject to Article 246A, Parliament has exclusive power to make any law with respect to any matter not enumerated in the concurrent list or state list. Such power shall include the power of making any law imposing a tax not mentioned in either of those lists. Article 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest. Notwithstanding anything in the foregoing provisions of this chapter, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary or expedient in the national interest that Parliament should make laws with respect to goods and services tax provided under Article 246A or any matter enumerated in the state list specified in the resolution, it shall be lawful for the Parliament to make laws for the whole or any part of territory of India with respect to that matter while the resolution remains in force. A resolution passed under Clause 1 shall remain in force for such period not exceeding 1 year as may be specified therein, provided that if and so often as a resolution approving the continuance in force of any such resolution is passed in the manner provided in Clause 1, such resolution shall continue in force for a further period of 1 year from the date on which, under this clause, it would otherwise have ceased to be in force. A law made by a parliament, which parliament would not, but for the passing of a resolution under clause 1, have been competent to make, shall, to the extent of the incompetency, cease to have effect on the expiration of a period of 6 months after the resolution has ceased to be in force, except as respect things done or omitted to be done before the expiration of the said period. Article 250. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation. Notwithstanding anything in this chapter, Parliament shall, while a proclamation of emergency is in operation, have power to make laws for the whole or any part of the territory of India with respect to goods and services tax provided under Article 246A or any of the matters enumerated in the state list. A law made by Parliament, which Parliament would not, but for the issue of a proclamation of emergency have been competent to make, shall to the extent of incompetency cease to have effect on the expiration of a period of 6 months after the proclamation has ceased to operate, except as respects things done or omitted to be done before the expiration of the said period. Article 251. Inconsistency between laws made by Parliament under Article 249 and 250 and laws made by the legislatures of state. Nothing in Articles 249 and 250 shall restrict the power of the legislature of a state to make any law which under this constitution it has power to make. But if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by the Parliament, which Parliament has under either of the said articles power to make, the law made by the Parliament, whether passed before or after the law made by the legislature of the state, shall prevail. And the law made by the legislature of the state shall, to the extent of its repugnancy, but so long only as the law made by Parliament continues to have effect, be inoperative. Article 252. Power of Parliament to legislate for two or more states by consent and adoption of such legislation by any other state. If it appears to the legislatures of two or more states to be desirable that any of the matters with respect to which Parliament has no power to make laws for the states except as provided in Article 249 and 250 should be regulated in such states by Parliament by law, and if resolutions to that effect are passed by all the houses of the legislatures of both of those states, it shall be lawful for the Parliament to pass an act for regulating that matter accordingly, and any act so passed shall apply to such states and to any other state by which it is adopted afterwards by a resolution passed in that behalf by the House, or where there are two houses, by each of the houses of the legislature of that state. Any act so passed by Parliament may be amended or repealed by an act of Parliament, passed or adopted in like manner, but shall not, as respects any state to which it applies, be amended or repealed by an act of legislature of that state. Article 253. Legislation for giving effect to international agreements. Notwithstanding anything in the foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, convention with any other country or countries, or any decision made at any international conference, association, or other body. Article 254. Inconsistency between laws made by Parliament and laws made by the legislatures of the states. If any provision of a law made by the legislature of a state is repugnant to any provision of law made by the Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then subject to the provisions of clause 2, the law made by the Parliament, whether passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and the law made by the legislature of the state shall, to the extent of the repugnancy, be void. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provisions repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such a state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in that state. Provided that nothing in this clause shall prevent Parliament from enacting any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state. Article 255. Requirements as to recommendations and previous sanctions to be regarded as matters of procedure only. No act of Parliament or of the legislature of a state, and no provision in any such act shall be invalid by reason only that some recommendation or previous sanction required by this Constitution was not given, if assent to that act was given, where the recommendation required was that of the Governor, either by the Governor or by the President. Where the recommendation required was that of the Raj Pramukh, either by the Raj Pramukh or by the President. Where the recommendation or previous sanction required was that of the President by the President.